A meritless lawsuit usually refers to lawsuits that are based on little or no legal merit and are filed mainly in the hope of securing a settlement. Many corporations are still willing to settle these type of cases because fighting them can actually prove quite costly, both in terms of the legal costs that are involved and also potential reputational costs. From the perspective of society, these type of lawsuits are harmful because they do not sanction any wrongdoing. They impose substantial costs on the targeted firms, and they also put a burden on the judicial system. Yet, some law firms still find it in their interest to file these type of lawsuits because the cost of filing them is relatively low, and yet the potential rewards in form of settlement can be quite large. In our paper, we show that meritless litigation targets innovative companies. And understanding whether there's a potential link between innovation and litigation is actually very important, because if meritless lawsuits target innovative companies, then the securities class action system might actually pose an obstacle to our general goal of fostering innovative activity in the economy. And in the end, it could actually slow down economic growth. A link between innovation and litigation risk has long been suspected by policymakers, by academics, and also by corporations. But what we found surprising when we were examining the empirical evidence on that argument was that we actually do not have any direct evidence that innovation triggers more litigation. We do know that litigation rates are higher in certain sectors, such as the technology sector, but that's not the same thing as saying innovation drives litigation. And in addition to that, we also do not know if there is a link, what could be the underlying channel that could drive it. And so this gap was our motivation to ask two main questions in this paper. First, is it true that innovation triggers more meritless litigation? And second, if that's the case, what could be the underlying reasons for why these two are linked? We use two main data sources for our analysis. The first piece of information that's very important, of course, is information on securities class action lawsuits. And we get these from the Stanford Securities Class Action Clearinghouse database that has a lot of information on all lawsuits filed in US federal court since the passage of the last big reform. So we know the nature of the allegations, we know who were the plaintiffs, what was the targeted company, and we also have information about the lawsuit outcome, whether it was eventually dismissed or whether it settled. And the second important piece of information is a measure of a firm's innovative output that was recently proposed by Kogan, Papanikolaou, Sarah, and Stoffman. What they do is they provide a measure of the economic value of a firm's patents by looking at stock market reactions to patent grants. So we find a causal link between innovative output and the likelihood of being a target of a meritless lawsuit. This relationship holds for various proxies for meritless lawsuits. So we use in our baseline measure lawsuits that end up being dismissed, but we can also look at ex ante measures, so characteristics of the lawsuit that you can observe when it is filed, such as the reputation of the plaintiffs or what was the nature of the allegation. Interestingly, we don't find any significant relationship between innovation and meritorious litigation. Then in the next step, we look at how costly is it to be target of a meritless lawsuit, and we find that it's actually quite costly. The average firm loses 2.2% of their market capitalization just in the days around the lawsuit filing. And interestingly, for innovative companies, it's actually even more costly. They lose around 3%. So not only are they more likely to end up as a target of a meritless lawsuit, they also bear a higher cost once they are targeted. And so combined, our findings suggest that meritless lawsuits impose a tax on successful innovation. In the second part of the paper, we try to understand what are the underlying reasons for this positive relationship. And what's interesting is that we don't find much support for the common argument that it's the stock price volatility of innovative firms that's driving the higher litigation risk. Instead, what we find is that there are changes in firm disclosure and in firms' investment opportunities that coincide with innovation that could explain this relationship. One important implication of our findings is that the cost of meritless litigation could actually be a lot higher than we previously thought. First of all, by targeting innovative companies, meritless lawsuits are punishing or draining resources from firms precisely when they actually need it the most. So when they're about to expand and they're about to develop the new ideas that they've been developing. In addition to that, it should also concern us what kind of disincentives meritless lawsuits could generate. You could imagine that they can provide disincentives for firms to invest in innovation in the first place, because effectively what they are doing is reducing the potential profits to successful innovation. Alternatively, it could also discourage innovative companies from accessing public equity markets in the first place, and therefore forgo attractive growth opportunities. This suggests that there could be some benefits to changing the securities class action lawsuit system in ways that reduces the problem of frivolous litigation. For example, by imposing sanctions on frivolous lawsuit filings. However, I also want to be clear that our paper mainly is able to speak to the cost of meritless litigation, and any effective reform would have to trade off the benefits from reducing frivolous litigation against the cost of maybe also discouraging meritorious litigation. And so we're not saying that all securities class action lawsuits are bad, but any effective reform would have to balance these two potential effects.